as more participants join. Welcome and thank you everyone for thanks for that. So welcome and thank you everyone for joining us today for the Sphere India Academy session on best practices on data protection and management for humanitarian sector. As most of you are aware, in the current digital age, data protection is a critical concern, particularly within the humanitarian and development sectors, where we see the handling of sensitive personal data quite commonly. As many of you are aware, during disasters and emergencies, humanitarian organizations often collect vast amounts of personal data to deliver aid and services effectively. And this data can include sensitive information about individuals' identities, locations, health status, and other personal details. Therefore, understanding the principles of data protection and implementing best practices is important for organizations to navigate the ethical and legal complexities associated with data handling in crisis contexts. Particularly during humanitarian and disaster response, protecting the privacy and security of individuals' data is essential not just for safeguarding personal information, but also for upholding the dignity, autonomy, and fundamental rights of those affected by crisis. With this context, it is our pleasure to collaborate with IOM India for this critical session, and it is an honor to moderate such an accomplished panel that has been working consistently on diverse aspects of data protection and management for vulnerable and affected communities. As we invite our esteemed panelists for their sharing, I request all our participants to take advantage of the experience within this group today and interact through the chat box with each other, and also to raise any queries or concerns related to the topic they might have. And we'll do our best to address these during our session today. And on that note, without any further delay, I would like to invite our first speaker, Mr. Saurav Adhikari, Senior Consultant and Lead at Policy and Development Advisory Group, who will provide us a legal overview of the Digital Personal Data Protection Act and its various components. Over to you, Saurav.
Thanks, Michelle, for that. And a very good afternoon to everyone participating in today's session. So my name is Saurav, and as Michelle said, I am a senior consultant and lead of the data solutions vertical at my organization, Policy and Development Advisory Group. And we primarily work on policy advocacy, research, and strategic communications. And so today, because I am the first speaker, and mostly what I'm going to set up in this next 15 minutes, the time that has been allotted to me, is in a brief about the DPDP Act 2023. What's the applicability of the Act? What are the different components? What are the rights of the persons or individuals from whom the data is being shared, is being collected, the roles of the organizations or the individuals who are actually collecting the data or processing them, and what are the current provisions within the Act regarding grievance redressal and other things like that. However, also we should be very understanding of this fact that while this Act came into force, I mean, it has not come into force yet. While it received the assent from the President in last August 2023, the rules and regulations around the Act are yet to be framed, and until that has been framed, we really do not know what exactly will be the larger aspects, or how it's going to be actually applied on the ground, right? We at the moment are just clear more about the contours of it. So on that, I'll also quickly share my screen. I have a very small PowerPoint to take every one of you through. Right. Is the presentation visible to everyone? If I could see a thumbs up, that would be great.
Yes,
Thank
it
you.
is visible.
Okay, so the DPDP Act 2023, it got the President's assent on August 2023, and it first came into the shape of a bill in 2019, and by the time it became an act, it saw multiple iterations, and there were changes also during those iterations. Some aspects were added, some aspects were dropped, but largely the act, which received the president's assent. These are the larger contours. So it basically deals with processing personal data in a manner where, number one, it recognizes the right of the individual to protect their personal data. Okay. At the same time, it also acknowledges that processing of such personal data for lawful purpose and other connected, purposes is probably necessary in this, digital age. Now, before moving on to the other, parts of the act, it's also very important for us to understand that this act very clearly demarcates between different types of data. So, if we understand data as like a whole sort of approach where, as per the act, it's representation of information, facts, concepts, opinions, or instructions, which is suitable for interpretation by either human beings or automated means. If that is the larger universe of what data is, within that, this act specifically talks about, number one, personal data. So any data that now helps us identify who does this information belong to, or these facts belong to, or whose opinion is being captured. So any personal data that makes this, the first level of the data identifiable, is being, or any identifier for that matter, is actually being suggested to be personal data. And within personal data, digital personal data is personal data in digital form. It also clearly suggests what the digital form means. So digital form could either mean where the data has been collected digitally, or it could also mean a data that has not been collected digitally. It has been maybe collected in a pen paper format or in some analog format, and has been subsequently digitized to fit into a digital format. So it covers for that. Moving on, I just want to quickly make us understand that who are the main entities defined in the Act. And the way it starts is there is the data principal. So the data principal is basically the owner of the data. To whom does this personal data belongs to? That person, that individual is the data principal. Now, this data principal, of course, before any data can be processed or can be analyzed from this data principal, there needs to be a process. The Act talks about how consent needs to be provided, and therein comes the role of a consent manager. A consent manager is basically an individual or a body who is registered with the data protection board. The data protection board, I'll come to the roles and responsibilities of the data protection board and what it is supposed to later on. But it is, let's say, the main body who is responsible to oversee that the provisions of the data protection within this act are being met, and to redress grievances and all of that. So the consent manager is an entity who is registered to the data protection board, who through some, let's say a portal or some mechanism, gathers the consent from the data principal regarding sharing this personal data. And once this personal data is available after this consent has been taken, who collects it? This collection is done by the data processor. Data processor is someone, an individual or an entity who is employed by the data fiduciary. The data fiduciary is basically, again, the entity who is responsible for collecting of this information, who is the final sort of the body that is analyzing information. For example, if we are signing up on Amazon to get some e-commerce goods, then in that case Amazon is the data fiduciary, and the data processor is an entity with whom the data it's employed by the data fiduciary through a proper engagement, through a legal engagement, who is collecting the personal data, let's say, on behalf of the data fiduciary. And the data fiduciary, if it is dealing with a huge volume of information, is dealing with huge, very sensitive information. In that case, according to the Act, they may also be designated to be specific, data fiduciaries. And when it becomes a specific data fiduciary, they also need to have someone called a data protection officer, which is sort of a point of contact between the data fiduciary and the data protection board, and the data principal, if any case there is a data leakage or something like that. So these are the main entities of this the act. Now, in terms of the components, first of all, it talks about the applications, that where is this act applicable, the territories in which this personal data could be processed. So currently, the act suggests that it can be processed within India, of course. It can also be processed outside India if the delivery and goods and services is happening within the territory. So it also allows for that. It also suggests that what are the conditions for non-applicability, and it specifically talks about where uh, uh, if such personal data is actually being processed by an individual for any personal purpose. Okay, so if it is not like a commercial purpose, if it is a personal purpose, then it's not applicable. It is also not applicable if it has been publicly made available by the data principal. So if someone goes and pastes their personal details on a social media platform, maybe on a Twitter, then it doesn't apply to them. Also, before I move on, I missed sort of defining that when you're talking about processing data, a lot of times we might feel like processing is basically manipulating the data. But as per the act, processing means number one, collection, number two, storage, number three, any process that is being done on the data, number four, also further sharing of the data, of that personal data, to other, let's say, parties. So in that manner, a data fiduciary, who is the main entity who is collecting this information, can actually engage multiple data processors for different aspects of the role. So one data processor could be just collecting it, one data processor could be analyzing, and so on and so forth. The second part is the rights and duties of the data principal. So the number one, so it gives that what are the rights, and I will come to detail regarding this because this is one of the important tenets. So I'm not taking too much time over here, but it gives 3 to 4 different rights to the data principal regarding consent, regarding getting a summary of the information that has been personal data that is currently shared with the data fiduciary, regarding that the ways grievance can be sort of redressed. Also, right to nominate someone to do these things on his or her behalf if that person faces death or incapacitated, and also some duties. It also points to us the obligations of the data fiduciary. So data fiduciary, again, the entity who is processing all this personal data. So what are the obligations of the data fiduciary? So it talks about free, specific, informed, unconditional, and unambiguous consent that this data fiduciary must be taking through the consent manager. The certain legitimate use cases of what this data could be used for, so it gives us a view of that. Also, that anytime the data is someone's personal data is supposed to be collected, they're also supposed to give like a notice to the data principal as to what is the purpose of the processing, how that I've obviously given my consent, but I can also further go ahead and withdraw, review my consent. So how do I do that? How to update, edit, or remove my data if I want to do that? And also, if there are grievances, how do I complain to the board? So all of these things, okay, they're also supposed to give as a notice, before the data principal, who is the owner of the data, accepts, to share the data through them. And number three is processing of personal data for children. So now there are, of course, commonalities with any other data principal, but if the data principal is a children in this case, then there are certain, again, other obligations that come into place, especially to do with how to get, how to get validity from their parents as to to get the data. So any person below the age of 18 years, as per the act, cannot actually himself or herself accept this notice and give the data out to a data fiduciary. It can only be done by the guardian of the child, and through, again, an informed consent that they have to provide. The other components are the Data Protection Board of India. As I said, that this is the primary body who is responsible for dealing with all complaints and grievances in terms of anything to do with data protection. And it talks about the establishment of the board, what is the composition of the members, who can be a chairperson, who cannot be, how can this board or these members, they could be disqualified, resignation, how vacancies could be filled, and the powers of the board, and also especially the powers of the chairperson. So it also talks about that. And finally, it also talks about the appeal and alternate dispute resolution. So, for example, if as a person I am really unhappy with the way my grievance has been addressed by this Data Protection Board of India, then I can appeal to the appellate tribunal. And it also talks about who that appellate tribunal is going to be, how are they going to deal with it, and alternate dispute resolution is basically mediation. If there is a possibility of mediation, then how can that be done? And finally, what are the penalties and adjudication? In terms of if the obligations are not being met, there are substantial penalties that are associated with it, almost in the range of 200 to 250 crores, per data fiduciary, depending on such conditions. Now, from there, just moving to the data protection rights and compliance. So, as a data principal, okay, if I'm the data principal, what are my rights? So, I have the right to obtain from a data fiduciary a summary of all personal data that has been processed by the data fiduciary, the data processors employed by the data fiduciary, and also if any such personal data has been shared with any other data fiduciary. So I collect as a data fiduciary, I collect the information. I also share that with another data fiduciary. So, I can also get a summary of that. Identities of all other data fiduciaries and data processors. So, for example, I know the identity of the primary data fiduciary, but who is this secondary data fiduciaries with whom my data could be shared? Who are the data processors who are working on behalf of the data fiduciary? Their identities I can get to know from them. But none of this is applicable if this secondary data fiduciary is authorized by law. So, for example, an e-commerce platform has collected some data about myself. There is a government agency who might think like I'm performing some fraud, in this larger scope, and wants some of this, let's say, information that can also deal with, payments and stuff like that. Then that becomes like an authorization, authorized by law. So over here, the secondary data fiduciary is, of course, the government or the government's, the investigative wing, whoever wants the data. So if the secondary data fiduciary is now being authorized by law, all this rights actually do not then apply to them. I have the right to correct, complete, update, or erase my personal data if I want to. I can not only personal data, but I can also update and withdraw my consent. So that is there. So one part is once I've given my consent, then but if I want to now withdraw my consent, I can also do that. And that has to be done through the consent manager. Also, I have available means to grievance redressal in case some of the obligations have either not been met by the consent manager or the data fiduciary. Has the right to nominate an individual to perform the principle, perform the activities of the data principal, exercise the rights of the data principal in the case of a death or incapacitation. And the data principle, in terms of duties, there are some specific, that we must bind by all applicable laws, that one shouldn't be impersonating another person while sharing this data with the data fiduciary, not to suppress any material information, while providing the personal data. And that one shouldn't be registering a false or frivolous complaint. So I've given a consent, or I know that this is what the data is going to be processed for, but then suddenly I raise some sort of a complaint. So all such frivolous complaints cannot be sort of registered. And authentic information is also provided, not only during the time of the first collection of the data, but for subsequent eraser or correction, if that's supposed to happen. Now, who is accountable for this, and also what is the governance structure of this? The primary accountability is very clear. It lies with the data fiduciary in this case. And the data fiduciary, the primary obligation, the most important obligation that the fiduciary must do is, of course, report all personal data breaches, number one, to the data principal, and number two, the Data Protection Board of India. And as I said, that depending on the volume of information and the nature of activities, a data fiduciary could also be classified as a significant data fiduciary, where there are further obligations that get added to this. So number one, they need to do they need to conduct a data protection impact assessment before they decide to start a large scale data processing activity. They also need to appoint a data protection officer who oversees all complaints and compliances with the act. Grievances from data principals also serves as the POC with the data protection board. And the DPBI, central authority, as we also said, responsible for overseeing the implementation of the larger act. And their primary roles are monitoring and compliance of this, addressing grievances and complaints, imposing penalties if there are cases of non-compliance that are registered to them. And their powers include investigating violations, summoning individuals, orders data fiduciaries to take corrective measures, and also impose penalties if they're found to be in violation of the obligations that they're in place. And if there are grievances against any order or direction of the board, then there is an appellate tribunal to whom an appeal could be made. So this is largely what I had in mind for today in terms of the legal perspective, the governance, the accountability, and the rights of the people, the data principle. Yeah, thanks.
Thanks a lot, Saurav, for providing that overview, especially with the draft of the rules under DPDP Act to be released soon and open to public consultation. It is very helpful to understand its various components. As we move on to the next section of this webinar, where we look at how different organizations working with different types of stakeholders implement data and information management policies within their organizational policies. I would like to invite our next speaker, Ms. Suraksha Chandrasekhar, Senior Project Assistant, IOM, for a brief sharing on IOM's data and information management practices. Over to you, Suraksha. Suraksha, if you're speaking, you might need to unmute yourself.
Oh, so sorry. Are we audible now?
Yes, please go ahead.
Yeah. Okay. So sorry about that. Good afternoon, everybody. I was just saying that before I jump into the data protection principles at IOM, I'd like to invite my colleague Alok to briefly introduce IOM and the work we do. Over to you, Alok.
Hi, Alok. You might need to unmute yourself as well.
I think it's unmuted.
Yes.
Yeah, you're audible now.
Okay. Thank you, Michelle, for organizing this webinar today on data protection and information management. In today's world, when we say data is new fuel, and all the businesses, all the institutions everywhere, data is something which carries an extremely important place for the success of the failure of the organization. And we, as an organizations working in the development sector, also dependent too much on data. And as a responsible organization, it's our responsibility to also keep the data protected, which we gather for development purposes. And IOM is happy to be part of this webinar. IOM stands for International Organization for Migration, which is part of the UN system. And we have offices around 170 countries around the world with 9 regional offices, more than 500 field offices. And what we do is we assist governments, we build capacity, we do a lot of evidence-based research, pilot initiatives on ground. What it means to say is that In India and across the world, IOM deals with a lot of data, and now because it's a large amount of data put together, IOM has its own data protection and management protocol, which my colleague Suraksha will be sharing with you. And there are few slides. Please feel free to keep note of your questions, which you can ask in the chat box or after the presentation. Over to you, Sharon.
Thank you, Alok. I hope the presentation is visible.
Yes, Suraksha.
Yeah. I'm not sure which slide I am on. So for IOM, our most important rule when it comes to data and data protection is do no harm. So for that, just for that, we have very stringent policies and regulations in place to make sure that the beneficiaries who we're reaching out to are being protected with the utmost standards put into place. I'm not going to go much into the definitions of, say, data and information and the differences because Mr. Saurav did just explain that very accurately just a while back. But what's important is that we have the understanding that information management is a continuous cycle because it's very important to the organization's learning activities, right from identifying the information needs, then putting into place on methodologies of how to acquire the information, how to accurately and robustly organize and store this information, develop information products and services, and distribute it through the right channels and means to migrants and migrant communities, and also use this information for decision making, for policy making, as well as for humanitarian assistance. It's very important also for us to continuously understand migration and migration related nuances because it's a very dynamic field. So we keep updating our policies and our regulations, and also have internal trainings and capacity building sessions for internal staff on how best to protect, secure, and utilize the information that we're collecting. So as Alok explained, there are two primary purposes when it comes to collecting information within IOM. One is, of course, for research purposes. That's where you have your needs assessments, your qualitative and quantitative analysis, and of course, for administrative purposes, such as for case management and registration of beneficiaries. But what is very important to us is we make sure that we never mix the two, because these two processes, they serve very radically different purposes, such as one is for acquiring knowledge, which is the research, and one is for providing assistance. That's where the administrative purpose comes into play. And these are also handled by different staff. They undergo different training, and they also are in different environments. So that's why we don't use data that's collected for research for screening and case management, and vice versa. I'm not going to go too much into this because Mr. Saurav had already explained this. But one thing I would like to highlight over here is that we look at personal data as direct identifiers and indirect identifiers. So direct identifiers are your obvious name, and then, for instance, even date of birth can be considered as a direct identifier. But then the not so obvious ones, such as IP addresses, GPS location patterns, even nationality. And for instance, when you're collecting qualitative information, something like family or household history, relationships with relatives, these are also basically indirect identifiers, which can lead you to identifying a person or beneficiary in this case. So these are factors that we are very mindful of as and when we collect information, and protection measures are being equally imposed on both. This is, yes, basically sensitive data. More examples on actually indirect identifiers. For example, sexual orientation, you may think might not be an identifier, like you might not be able to identify a person, but it can very, very easily lead to a person, or at least, for instance, where they live or where they're studying, etc. So it's very important to keep especially these factors in mind when it comes to collecting information. Data subject rights. Well, a data subject is basically an individual who, as I just explained, can be directly or indirectly identified through the personal data. So they have a certain set of rights that we ensure that these rights of the beneficiaries are protected, such as right to be informed, right of access, right to rectifications, and all of these you'll see how they're being embedded into the IOM data protection principles. Now, moving on to data protection. Data protection is basically about protecting people's information, because protecting personal data means protecting people. So it's measures need to be put in place to help protect them from harm and also uphold fundamental rights such as right to privacy. So now diving into the 13 data protection principles that we have in IOM. First one is lawful and fair collection. This is pretty obvious that data must be obtained by lawful and fair means, and consent is key over here. Data should be collected again for a specific purpose, and this specific purpose should be conveyed to the beneficiary while you're collecting their data. Data quality, of course, standards must be put into place so that only adequate, relevant, and not excessive data that is more excessive than the specified purpose is being collected. And of course, data controllers should take all reasonable steps to ensure that this data is accurate and up to date. Consent goes without saying. Basically, all groups or beneficiaries whose data are being collected should be explained, like sufficient knowledge should be given to them so that they understand why their data, or how their data is being utilized, for what purpose, and how it's also eventually going to benefit them. It's very important to collect data right at the outset of data collection, but if that does not happen, whenever whenever it's possible to collect data, consent, it has to be done. Transfer is when data is being transferred to a third party. Of course, explicit consent should be taken from the beneficiary, and also this should be based on a specified purpose. Confidentiality also goes without saying. It must be respected and applied to all stages of data collection, and also should be guaranteed in writing. And all IOM staff and individuals actually representing third parties who are authorized to access and process this personal data are bound to confidentiality. Access and transparency. Data subjects, they should be given the opportunity to verify their data. To also, so basically we provide them access to this data that's being collected. So basically there has to be like a general policy of openness towards data, towards the data subjects about the development, the practice, the policies with respect to personal data. Data security is, basically data has to be kept secure, and it has to be protected by reasonable and appropriate measures against unauthorized modifications, tampering, unlawful destruction, accidental loss, and we'll get more into this in the subsequent slides. So retention is basically if once the purpose of the data that's being collected, once that purpose runs out, then the data should be destroyed or rendered anonymous, unless there is a need for for the benefit of the data subject, maybe with future projects. If there is a need to retain this data, then that specific purpose again should be stated explicitly, and the beneficiary should also be conveyed. This should be conveyed to the beneficiary. Applications of principles is, yes, these principles should be applied to both electronic and paper records. And IOM assumes all ownership of the data that's being collected, and measures are taken to remedy any unlawful data collection or data processing, even breach of rights and the interest of data subjects. And we also we have the IOM Legal Affairs Department in case there are any exceptions or any support we require when it comes to data protection and also how to secure it better. We reach out to them. So data security, the difference between data protection and data security is that the way we see it is that data protection is mostly to do with the internal measures that are put in place to protect the data better. For instance, like the data collected is only being accessed by authorized personnel, whereas data security is measures that are taken to protect the data against the risk of accidental destruction or loss or alteration. So basically the extra layers such as like, for example, a multi-factor authenticator that Microsoft Teams has, like we have to put codes twice or thrice for us to get access to such information. Those kind of 2-3 layers that are put in place so that only authorized personnel can access that data is something that we keep in mind, and it's also how we see the difference between protection and security. So just a couple of do's and don'ts. Data security, when it comes to data security, is that you for instance, lock the file rooms and filing cabinets. Again, you use like MFA, and only authorized personnel can access these data. And even other smaller things that we put in place. Example, while writing emails, making sure that the beneficiaries' details are not very explicitly mentioned in the email. So these are like small things that we're also taught to do, like through trainings and capacity building. And then, of course, you don't leave the case files open. Like in open, you make sure you use strong password and username. And these other small things, like we also don't use WhatsApp or Facebook Messenger to also share such data. And we only stick to Microsoft Teams. So overall, the organization has very strong and robust data protection principles and also approaches that we take. And yes, we'd be happy to answer any questions and happy to share more information on this as well. Alok, if you have anything to add, please jump in. Over to you, Michelle.
Thanks, Suraksha, for sharing about IOM's data management principles for specific informed consent and purpose for the data collected, and also differentiating between data protection in terms of internal measures and also data security to protect the collected data against accidental or intentional tampering from external sources. So it is my pleasure to invite our next speaker, Ebba Hansen from Voluntas Advisory Private Limited, who has worked extensively with different groups of stakeholders to share on their data protection practices, highlighting successful strategies and common challenges. Over to you, Ebba.
Oh, thank you so much. It's such a pleasure being here today discussing this very important topic. So thank you for having me, and thank you to Sphere India and IOM India for organizing it. My name is Ebba. I'm the head of office for Voluntas Mumbai. What I would like to discuss today, briefly just give you a little bit of an outline as to who Voluntas are, and then also talk about our data protection principles, perhaps in a more applicable context, trying to give some examples as to how we operationalize this while conducting large-scale data collection, and then subsequently also talking about some best practices in relation to some specific projects, and then also challenges as we discuss those as well. But let me go ahead and share my screen. All right, so just a little bit briefly about who Voluntas are. So Voluntas is a global advisory firm, and we specialize in strategic research and policy development. We have a purpose of realizing potential and live by the philosophy of meaningfulness as a better way of constituting societal progress compared to some existing indexes and parameters. But we have just under 100 employees worldwide, with offices in Denmark, Germany, Norway, Ukraine, Tunisia, the US, Kenya. We also did have in Sudan up until recently, and the Mumbai office was established around 2 years back. As mentioned, we have had the opportunity and the privilege to work with a lot of multilateral organizations, as well as government agencies in quite volatile and conflict-prone areas, whether that be working with internally displaced persons in Sudan, whether that be working with refugees from Ukraine. These are, as you understand, very vulnerable communities, and therefore data protection is of uttermost importance, of course. We do have quite a lot of experience in conducting large-scale data collection with local data collection partners across these different countries and areas. So happy to share some of our data protection principles with you here today. Given that we are a global advisory firm and that we have offices based out of the EU, we are bound by GDPR. So the General Data Protection Regulation that was put into place or came into force as a EU regulation back in 2018. So as a global company, we have been making, or we started this transition towards being GDPR compliant back in 2018. And there are quite a lot of similarities, I mean, extensive overlap, I would say, to the Personal Data Protection Act. So similarly to the Personal Data Protection Act, it looks at collecting data on lawful basis, the rights of the data subject, also similar to what has been discussed previously in terms of the right to know what your information will be used for, the right to retract it, the right to erase it, the right to retrieve it. But also data protection in design and defaults, data security, data minimalization and accuracy. All of these are thematics of GDPR and also of the Personal Data Protection Act that we enforce in our data collection practices as well. So in practical terms, what this transition has meant, everything from having very strict need to know access in terms of client folders and also personal data, but double authenticators, password protected files, whitelisted IP addresses, only not sending any files that are downloaded documents, but only as links, etc., etc. But if we are to understand a little bit more around our data protection principles across the data management cycle, so to speak, in a development and humanitarian sector context, and then I've just divided into the different phases of the data management cycle. So we have project design and inception, we have enumerated training and data collection, we have data handling and quality assurance, and data storage and integrity. So as we've already touched upon, the data minimalization is of essence, that you only collect, that you only design the project, you only outline the survey instruments and questionnaires so that you retrieve what you need and not excessive amounts. So collecting certain amount of information may be authorized whilst not collecting others. For example, if you're conducting a research study on access to healthcare, there's no reason to collect data on criminal track records, for example. So just being very intentional about not collecting irrelevant or excessive information. Then we've already spoken about consent management, of course. Here, it's very important that it's not only consent, but it's informed consent, that everyone knows exactly what the data is being used for. That may require surveys in different languages. That might require explaining to the person in question multiple times. It can also be that you may consent to use, say, a transcript of a KII, but you may not consent to being cited. So being very mindful about what is it you are taking consent from the beneficiary. To give an example, just last week we conducted data collection in schools. This was something that was touched upon, what is actually applicable when you collect data from children. Last week we had 4 members of the team going into schools, and there beforehand we had both obtained the principles of consent, but also had distributed consent form to all the parents whose children were participating in data collection. So whoever we had not obtained consent from the parents, we did not ask any questions. And then the child also gave their consent. So it was consent both from parental consent and also child consent as well. Then, of course, legal and regulatory compliance, as I've already spoken about, we have GDPR, and of course, also the Personal Data Protection Act. A lot of overlaps between the two, I would say. When it comes to enumerated training and data collection, enumerated training, I would say, is a little bit more around the data management cycle as opposed to protection. But the point here being that it's all well and good that we have these principles or that IOM have these principles, but if they're not translated and manifested through enumerators, especially if you use data collection partners, then what's the use, right? So we put a lot of emphasis on the enumerator training, and as I will show you on the next slide, that can mean hosting multiple enumerator trainings for the same enumerators, just to ensure that the context is understood, that the reason behind the question is understood, what is feasible to collect in terms of personal data, what's not, etc., etc. So the enumerator training, I would say, is essential for us to uphold our data protection principles, and we put a lot of effort into that. Access control. So now I'm taking examples from projects in India, but all our enumerators collect data on tablets, and that can be so that's server-based Android applications. It can be Survey CTO, it can be ODK, it can be Quest, and they are specifically asked not to collect any data besides on these tablets. They're not allowed to record any data on, informal scribbles on a notepad or anything like that, because then it's very difficult for us to ensure that no unauthorized access is given. So everything needs to be collected on these tablets, and no enumerators have access to the larger pool of data collected. That is only the only people who have authorized access to that is the team leaders on a state level of the data collection partner, and then Voluntas. And even to log into that, even if they share a link with us, it's email ID specific. So there are multiple steps to ensure that there's no unauthorized access to that data. We don't collect any names. No names, but of course other personal data that by which a respondent could be identifiable. 10% of those, typically those we collect data from, are asked whether they would be willing to share their telephone number with us. But even if they do, it's made very explicit that this telephone number is only used in terms of data quality assurance. So that's also very important to distinguish which data is used for what. Data anonymization, as mentioned, we don't collect any names of beneficiaries. Data accuracy, again, here is where enumerator training comes into great importance, because we want to make sure that the right data is collected, that not any excessive data or information is collected either. Secure data transfer, there I've already spoken, I've already addressed that. Field level validation, so quality assurance is also important principle of our data protection principles as well, because it all comes back to data accuracy. If we're not collecting the right data, then, I mean, protect it all we want, but if it's inaccurate, then doesn't really serve the purpose. So we have very rigid data quality assurance strategies, which I will speak a little bit in further detail about in relation to one of our projects. We also do audit trails, so maintaining logs of who accesses and modifies the data during the handling and quality assurance processes. Secure storage solution, as I mentioned, it's very much a need-to-know basis for even the team within Voluntas to be able to access this data. If you're not on the project, if you're not handling the data itself, then you do not have access to it. And as I mentioned, even if we're printing something out, that printer needs to be registered on a whitelisted IP address, and all our computers are changed passwords as well on a monthly basis. Data backup as well, and then finally secure retention on online server with, again, restricted access. So those are some of our general data protection principles. And I just wanted to take a minute or so to hone in a little bit on quality assurance as one component of data protection principles, and can give a few examples of a project that we are conducting together with IOM, Prayas, which seeks to improve and assist international migration of aspiring laborers and students moving from India to abroad. This is a quite large-scale data collection. It involves collecting data from up to 10,000 people, 4,000 aspiring labor migrants, 3,000 student migrants, and 2,000 high-skilled professionals across 15 states. So it's quite large-scale data collection with a lot of stakeholders and a lot of data quality assurance that needs to be put into play. So just just a few, concrete examples of training of enumerators. I come back to this a lot of the time, but we can have all the data security and protection measures in place, but if it's not adhered to by our local data collection partners, then it really doesn't matter. So we are very rigid in terms of for this project, we did 2 rounds of enumerator training, so 2 sessions initially. After the pilot survey, we did rigorous quality assurance to see what the enumerators had understood in terms of the context of the project, as well as the data that they were supposed to collect. And then we did a refresher training subsequently. Then in terms of the quality assurance plan and data protection principles at that point, so there are multiple checks and balances that we conduct to ensure that the data accuracy is compliant with our data protection principles. So that can be anything from looking at, what is the logical cohesiveness of the answer by respondents. It can be, does it make sense, the destination country that has been put in by the enumerator? What is the duration of the interview? What is the average interview conducted by a enumerator per day? For example, we had an incident in one state where we saw one enumerator collecting 120 responses within a week. And then that does not only beg questions of data quality, but also, how this enumerator is acting or interacting with beneficiaries. And whether the time is given in order to explain the context and ensure informed consent. So all of these go to say that these are regular checks that we conduct, and then have a feedback mechanism to enumerators, a data back check, you could say. Other tools we implement are mandatory GPS location, the distribution of responses as per location, so they're not concentrated within one area. And then, of course, every respondent can be matched to time and place and enumerator, again, to ensure that there's no corruption of the data or that there's consistency in what beneficiaries are saying. And finally, also governance and management structure. So with our local data collection partners, it's we institute weekly calls, we conduct field visits, we ensure that we have state-wise reports on daily enumerator activities on a weekly basis. So there are multiple accountability measures put into place to ensure that the data collection is being handled in accordance to our data protection and security measures. In terms of a few challenges, I think I'm in the interest of time, I will have to hurry up, but just a few challenges we've faced just on a few recent projects when it comes to data protection. One is, as mentioned, ensuring informed consent. So just going beyond a yes or no, and that will obviously need to be adapted depending on whether it's a focus group discussion, whether it's key informant interview, whether it's a survey, etc., etc. But equipping enumerators to really being able to answer questions as to why are you collecting this, where will it be used, what implications will it have on, in this instance, my ability to migrate, because it's very easy to say that we get informed consent from everyone we interact with, and of course, yes, that is what we're here to abide by. But in terms of field realities, then you really need to ensure that enumerators feel equipped to give this principle justice. whether that's the different enumerator trainings, whether that's giving a flyer of a checklist as to how you approach respondents, etc., etc. Then data collection targets. In terms of collecting the number of respondents needed on, say, a district level or state level, you often put targets, right, to ensure that you meet, okay, we need X number of respondents within the next 2 months. And this is something that we've implemented to hold ourselves, but also our data collection partners accountable. But what we've seen on occasion is that these targets supersede the importance and legitimacy of the data quality. And I mean, that's something that we simply cannot jeopardize. So rather than having too rigid data collection targets, we've made sure to accommodate, I mean, you need to do it on a district level or state level or region level to ensure that we're data collection partners or enumerators are not, that meeting a target doesn't take precedence over ensuring informed consent or duration of interview. And then again, just a practical example from one of our recent projects with IOM as well is stakeholder management challenges, especially when you're doing complex and extensive data collection, which involves multiple different stakeholders, universities, advisory firms, recruitment agencies. All of these will have their own protocols in place that they abide by, and accommodating our data protection principles to also ensure that we have the full transparency and are equipped to combine that and align that with all the different stakeholders that we are communicating with can be a challenge at times, but there you just need to stand extremely firm and know exactly what your data protection and security policies are, and then you feed those external stakeholders into that framework. So I realize now it was quite a little bit on data quality assurance, but I would say that's one of the key pillars of data protection and security principles as well. So I hope that was helpful. Thank you so much.
Thanks a lot, Ebba, for sharing about your organizational policies on data protection and management, and also emphasizing on along with compliance with various organizational as well as larger rules and regulations to translate those policies through your partner organizations, enumerators, etc., to ensure compliance at the ground level as well. Thank you so much for sharing. And next, I would like to invite Debabrita to share from her significant experience working with Bal Raksha Bharat, one of the leading humanitarian organizations in India working with children, on practical steps and guidelines for developing and implementing data protection policies. Over to you, Debabrita.
Thanks so much, Michelle. And is my screen visible? Is the PowerPoint showable?
Yes.
Wonderful. Thank you. I'm really happy with my previous speakers for setting the context so beautifully. They have given us the legal framework. They have given us examples of how exactly practically different organizations try to protect their data, and what are the different challenges and risks, and preventing security breaches, ways of preventing security breaches are. So that actually makes my job pretty easier. So I'm here to I have been given the topic that why don't we discuss about implementing data management policies in terms of practical steps and guidelines as to how we develop a data protection policy for an organization, and what are the things to keep in mind while we are doing that. So I'll try to use my operations experience in in both development and humanitarian grants and try to use that experience in terms of developing this set of guidelines. And I'm happy to discuss further beyond the presentation as well, beyond the scope of this webinar as well. As may be needed. And having said that, let me give you a brief idea of what Bal Raksha Bharat is, and I mean who we work with and where we are. And basically, Bal Raksha Bharat is an organization which is globally known as Save the Children. We are present in 120 countries around the world, and we work very in a very focused way with children, their families, and their communities. And we are a dual mandate organization. We work in both development contexts as well as humanitarian contexts, as well as peace building and nexus contexts. So having said that, and I also must confess that I have drawn heavily on the Indian legal provisions as well as our own organization's policy, and apart from my operational experience, that is. So the two things that I'm targeting to discuss over here is, one is what are the practical steps and guidelines, and the second is what are the tools and resources that we can look at. Doesn't mean web references, of course, but practical resources. But before we go into that, so let me just take a look at what are those, what are those resources, information resources, knowledge resources that we need to have in hand before we go into developing a policy, and draw upon our own organization's context and experiences, and how we work with people, what kind of work we do, what are those specific target audience that we work with. So all those kind of considerations will come into play, because for example, as Saurav explained very beautifully, when we are talking about children, how we take the consent of children or a person with disability is a little different, is a little more stringent than how we take the consent from a person who can think for, who is legally allowed to think for himself or herself, for example, who is not a minor, or who does not have any kind of cognitive disability. So those kind of issues will always be there. So that is why it is very important also to understand the context of our own organization, the context of our own work, while developing a data protection policy for our own organization. So some of the things that we need to be very, very aware of are, what are the legal provisions available? As explained by our first speaker, Digital Personal Data Protection Act 2023 clearly delineates the entire framework. For example, it lays out who are the principal stakeholders, what are the principal actions that has to be taken, if there is a preventive action to be taken, what those can be, if there is a security breach despite preventive actions, there has to be some kind of reporting, and it is mandatory. So the entire framework, the legal framework, has to be understood first, where we are, what is our role in terms of the legal framework, and we need to also understand exactly who will do what in our organization. The organization may be small, the organization may be very big. Depending on that, it can be a separate assignment of a data protection officer, for example, or it can be someone already working in the field, already, or is there in the senior management, who can be nominated to be the DPO for the purpose of this act and the policy in the organization. However, it is better if we incorporate the views and the challenges faced in practical reality by everyone in the organization while we are formulating our own data protection policy. We need to understand exactly what personal data means, not only in the context of the legal framework, but also in the context of our organization. Who are our principal stakeholders? Like, for example, when we're talking about a data principal, who are those people whose data do we take? Data fiduciary in this case is my organization. And when we are talking about data principles, who are those people? Are those children only? Are those youth? Are those people who are adults and who have the necessary cognitive ability to make their own decisions? Or are there people who people with disability who would have some kind of cognitive functional impairment or something? So exactly who is our data principle? It is very important to clarify that in the very beginning. Second is what constitutes consent. Something that two or more of my speakers repeatedly mentioned is informed consent. Consent has to be very clear, very unambiguous, and very much verifiable by external parties in case of any kind of dispute. So before we take consent, it is always better that we explain exactly what is the purpose for which we are trying to get this personal data, and what is the duration of storage or use period that will be from our end. And that is something that is very important before we try to tell them कि भैया आपका आधार नंबर चाहिए, प्लीज आपका हाँ या ना बोल दो. That is not the way it is done. What I meant to say in Hindi is, please give me your Aadhaar number because of this reason. And that person says yes, because it's a humanitarian context. That person might have lost everything, and you are offering some kind of kit that you are going to distribute. And that person thinks that, okay, fine, at least some compensation is coming to me. Let me give my Aadhaar number. What is the problem? But that might lead to something of a very different nature down the road, sometime down the road, provided we are not careful about storing that data or deleting that data when the purpose is done. So it is very important that we tell them exactly for this purpose I'm taking your data, and we limit ourselves to the use of the data for that particular purpose only. So that is something which is very important. The third thing is very important, which is very important, is what exactly constitutes unauthorized use of data or unauthorized access or loss or theft of personal data, and what do you do in that case? Yes, there are certain penalties which are laid out in the legal framework, but also there has to be some kind of your organizational internal reporting mechanism first. Like if I am suddenly missing some kind of participant list, I need to immediately inform someone who that someone is in my organization, or even beyond my organization, whom do we report a security breach. So those are some of the things that needs to be laid out in the policy. Then of course, what are the compliances that we need to have within the organization to ensure that we are not violating any of the legal provisions laid out in the Digital Personal Data Protection Act. For example, how are we storing the data? How are we securing the data while it is in use? Right? So all those kind of things. There also has to be some kind of privacy policy which restricts the access of the data to only those people who need to use the data and only for the purpose for which it has been collected. There also has to be some kind of data retention policy within this overall data protection policy itself, which tells us that only for this particular period we can retain the data. After that, it has to be erased, and in a way where it cannot be retrieved by a third party. There has to be certain security measures in place. It can be as simple as an undertaking by our team members on ground that we will not be disclosing this data in any way. It can be as simple as not using our personal devices or mechanisms for conveying or transporting that data. For example, we do a lot of data collection by smartphones and tablets nowadays. So how do we ensure there are security measures in place so that none of the data collected remain in the personal devices of the people who are collecting the data through such digital measures? There also needs, before we finalize this discussion, there also needs to be some kind of impact assessment. We need to understand where our data are. We need to map the data. the data flow also, and who are the data holders in the organization, and how protected the data is right now at this point of time in the hands of those people. So that is a very important assessment that needs to be done, so that we can understand exactly this is the level where we are, and this is the level where we need to go. So that also needs to be, feed into the policy. There has to be some kind of regular schedule of training and orientation of the employees. For example, I could hear from my previous speakers that some of the organizations are research focused, so they will be employing enumerators for each and every study. Some of the organizations will be like us, who do direct implementation on the ground, and any kind of baseline or inline survey, apart from the the really very big ones, which we have outsourced. Apart from those, we usually tend to do the entire thing by ourselves through our own staff members or volunteers, who have been taken for that particular grant duration, that particular hour duration. So in that case, they have to be trained and oriented on the data protection policies and penalties and the security measures that we are taking, what can be done, what cannot be done, some list of do's and don'ts, and of course that undertaking or a non-disclosure agreement would be very, very much preferable. But sometimes it is not possible to go for a non-disclosure agreement with every single person. In that case, at least an undertaking goes a long way. Also, a regular schedule of monitoring and review. What exactly has been done, what steps have been taken, and whether we are on the right track or not. If we have deviated somehow, or if we have not understood somehow correctly, then what can be done to course correct and move on, go on to the right track. So monitoring and review is also pretty important. For big organizations, there is always a legal department available, and you can actually talk to your legal counsel to make this data protection policy as resilient and as strong as possible. However, if you do not have access to a legal counsel, you might see how you can get that in order to make your data protection policy very strong. Apart from the DPO that you are nominating, you should also try a cross-functional team, which will be the data protection committee and a grievance redressal committee as well, under the leadership of the DPO, to take this policy and its actions forward. That will help you to socialize the policy, as well as ensure the regular training and orientation and the monitoring and the review, all those specific parts. And that will also help people to understand exactly how to take this policies actions forward within the organization and in the context of your organization. So when we are looking at it, any collection of personal data, as my first speaker very beautifully mentioned, it can be digitized to begin with. It can be non-digital, but subsequently digitized. It can be used within India or outside. If it is used outside, we need to ensure that if the government of India has some kind of notification in place already, that these are the countries where it cannot go. So we need to be in line with that. And we need to also ensure that it is also for some purpose which ensures that some kind of goods or service can be provided to the beneficiaries. For example, in the humanitarian context, I am, say for example, taking funds from an entity which is in a country which is not India, and they are sending me funds for a particular purpose, which says that I will be providing hygiene kits to 5,000 households. So then what I'm trying to do is immediately I go and do some kind of survey, right? I try to get some kind of identifier, maybe not direct identifiers, which give them their names and those kind of data, but at least some kind of indirect identifiers, because I need a list of 5,000 households, which are again verifiable by the donor organization, so that they can understand that we have not committed any kind of frauds, which is verifiable by the Indian government, because I am getting foreign money. and which is also something that lets me give them the goods in a very transparent way, but at the same time which can be erased out of my system once the entire activity is done in agreement with the donor organization. And there could be agreements in place where the donor organization can be given access to view at least the database to check that we are not performing any kind of wrong action. We are true to our words, we are accountable to the people, and we have selected the right people, and we have also done it in a transparent way. So checks and balances are always there, and some checks and balances will require the data as at least viewable by people from other countries. So this is just a small example. You might have scores of other examples where you are you have to have some kind of give some kind of access to the data before it is being erased out. So how do you secure the data even during that kind of viewership access? That is also something that needs to be kept in mind when you're formulating your own data protection policy. So we can think of a huge number of surveys, household surveys that we do ourselves, even as a direct implementation organization. Child vulnerability mapping, poverty mapping, participatory gender analysis, where we take a lot of sensitive information, right? So how do we collect the data? How do we process the data in terms of we may be entering it into Excel sheets, or we can be using cloud-based statistical software. We can be using desktop-based licensed statistical software. How we are distributing those data, how we are afterwards, maybe in a even in a development context, for example, we are giving out books and study materials. So there could be distribution lists or master roles for that. So how do you dispose of those kind of distribution lists and master roles? What happens to the digital data? What happens to the hard copy data? So all those kind of things have to be considered when we're developing your data protection policy. Another thing that is very important to keep in mind is most of the times we are using cloud-based mechanism for either analyzing the data or collecting the data, or maybe even storing the data. So what kind of security mechanism we have in the face of continuous malware and phishing attacks that we face, all of the organizations face sometime or the other. So that is also very important. So some of the common security breaches occur when the data is actually being collected, or either being analyzed or processed or being used or stored. So the first thing that I'm repeating here is, and that this is something that I think almost all the speakers have spoken about, is consent has to be unambiguous, consent has to be informed, and consent has to be verifiable. It may not be required for certain exceptional cases, but for most other cases, it is very important that that consent can be verified as an informed consent, and a very clear one. There should be no ambiguity in the consent process. Whatever data we are collecting should be accurate, complete, and consistent, and there should be checks and balances within the data collection process itself, whether it is in the schedule that we are administering, or within the series of questions, or wherever it can be. We have to have some, it can be monitoring, it can be checking random sets of schedules that has come in with the data to ensure that the data is accurate, complete, and consistent, because it is very important that we do not store the wrong data. Another is, as I was mentioning earlier also in the first point, the legal basis why I'm doing this and rationale of the data collected needs to be communicated very, very clearly, so that we are completely transparent and accountable to the people we are working for, to the children we are working for. One more important thing regarding the consent is, and this is also something that I'm repeating once again, is the data can be used only for the purpose it is collected, and the storage period has to be limited. It should be specified, and data integrity needs to be maintained. And if the data principle suddenly says, no, I don't want you to use my data, you delete it, we are bound to delete it. We have to. And the data principal can access their own data, not the rest of the database. And they can actually demand any kind of correction as well. And any kind of grievance they have can be communicated to the grievance redressal committee that we need to form under the data protection officer. If you remember in the last slide, I was talking about three things, three sorts of roles. One was the data protection officer. It would be good to have some focal point within the organization who can steer the entire thing. A data protection committee who will help the entire socialization process and the other actions that need to be taken regularly, and a grievance redressal committee who can be, be the focal for these kind of queries or questions or, requests from the data principals. Security breaches can be very simple, like a vendor representative is sitting right beside you and by mistake you just
in view of time, just asking you to wrap up in a few minutes.
This is my last slide actually. So just sitting right beside you and taking a look at your maybe desktop as to a participation list. It can be as complex as a database breach or a system breach due to phishing or malware. So what we need to do is, in that case, we have to have some kind of scenario-based incidence response standard operating procedure in terms of, if this happens, what do we do? Step by step, these are the things that we need to follow. We also need to have a reporting mechanism within the organization so that we can immediately start following that incident response SOP. We also need to ensure that we are preserving the evidence and documenting everything. We need to inform the stakeholders whose data is at risk. We need to fix those vulnerabilities, and based on the post-incident analysis, once everything is done and the appropriate authorities have been informed and they have done the forensic investigation and we have fixed the vulnerabilities, let's do a post-incident analysis, and based on that, let's offer remediation and improve our systems. And that provision should be incorporated in the data protection policy itself. It should also come with guides and frameworks if possible. If not, at least the policy is very important. Staff should ideally sign a non-disclosure agreement. If not, at least an undertaking should be there. Repeated system and compliance audits should be done to ensure that personal data of other people are not being used either for the purpose it is not taken for, or it is being retained even after its use. So those kind of things has to be done. Personal devices which should also be discouraged, and as much as possible we need to ensure that there is no personal data exchange mechanism to transport data which is for the beneficiaries, which is taken from the beneficiaries. Data mapping, I have already spoken about. Employee training, yes. It is very important to review your policies periodically and ensuring security safeguards, especially where third party is involved. For example, de-identification. If you're using a lot of photographs and videos, how do we blur the face if the person is not interested in showing their face? Encryption of data, protection against willful destruction and all that, restricting access and all that. So that's about it from my end. I'm happy to discuss whether within this webinar session or even beyond it. Thank you. Thank you so much.
Thanks, Devajita, for sharing steps and guidelines on how organizations can implement data protection policies. We have our last speaker. I know we are running out of time, but I would like to invite Dr. Rajratan Lokande, Senior Monitoring and Evaluation Advisor from International Planned Parenthood Federation, to share from their organizational perspective on how we can ensure data security in high-pressure, rapid response scenarios. Over to you, Doctor.
Yeah. Thanks for giving this opportunity on behalf of International Planned Parenthood Federation to present on these challenges and the solutions. Uh, so the collection of personal data is crucial for provision of humanitarian assistance. It allows the humanitarian actors to identify those those in need and deliver aid where necessary. Protecting individuals' personal data is an integral part of protecting their lives and dignity. Recent developments in the new technologies have meant that the processing of ever-increasing quantities of personal data in an interconnected world has become more easier and faster. It has also given rise to concern about the possible intrusion into the private sphere of the individual and to regulatory efforts worldwide to respond to these concerns. So this handbook on the data protection in humanitarian action is a joint product from the Brussels Privacy Hub, the Academic Research Center of RISI University Brussels, and the International Committee of Red Cross Red Crescent Society. Just to give a broad perspective of the consequence of inadequate data protection, certainly the breach and the downfall can lead to significant financial issues. Inadequate data protection can lead to legal and the compliance problems, as organizations must adhere to the regulations to maintain a level of security for information systems and data. Reputation, the news of breach can and will disrupt the organization's reputation, including branding and visibility. And certainly the breach can often lead to the operational disruption that halts the staff and the intervention activities. I'll quickly go to this, expand furthermore on the data protection challenges. The ever-expanding data landscape presents many data protection challenges at both individual and organization level. First of all, balancing the security and the privacy. Robust security systems are crucial for safeguarding the sensitive information. However, these measures can sometimes come at the expense of individual user privacy. Finding a right balance between the strong security and the individual control over personal information remains a complex task. The data ownership and control. Who truly owns the data that we generate online? The data protection regulation empowers individuals with some control over their own data. But the concept of ownership in this digital age remains a complex and evolving issue. Cross-border data flow. Now, the information can be easily transferred and stored across the geographical locations. Countries have varying data privacy regulations, making it difficult for the humanitarian agencies to ensure compliance when user data is collected in different jurisdictions. The rise of the third-party data sharing. Humanitarian organizations often share the user data with the third-party vendor for various purposes, certainly like developing fact sheets or analytics. Individuals may not be aware of the extent of data sharing and who has access to their information. The data protection regulations are increasingly focusing on the transparency and the user control over such third-party data sharing practices. Evolving regulatory landscape. Regulations in the world of data protection are constantly changing. New laws have raised the bars for data privacy protection, but complying with the growing number of regulation across different countries and regions can be a complex and costly endeavor, especially for the humanitarian agencies. International NGOs operating globally need to navigate this complex regulatory landscape to ensure they are protecting the user data in accordance with the national laws. Data visibility. With the massive amount of data exchanged daily, understanding what data exists, where it resides, and who has access to it, and how it is transmitted becomes critical for an organization data security. The data protection officers a natural concern about the visibility as it forms the foundation of the proactive security measures. Without a clear picture of their data landscape, organizations struggle to implement effective protection strategies. Identifying data requirement protection. Not all data is equal. Some informations like financial reports or health data, in that case, gender-based violence-related data, requires extensive protection. Others, like publicly available advocacy materials, can be shared more freely. Implementing a data classification solutions help organizations apply markers to sensitive data, allowing streamlining the secure exchange without unnecessary restrictions that could hinder the productivity. Proliferation of the devices, the surge in the connected devices from laptops to smartphones to wearable and smart home devices poses challenge in securing data across various platforms and endpoints. Organization needs to develop a comprehensive security strategies that addresses these unique vulnerabilities of these diverse devices. Increase maintenance. Certainly, the more the data, the more is the cost. So maintaining robust security measures becomes costlier and more complex. The humanitarian organizations need to find ways to scale the security infrastructure efficiently while ensuring adequate protection of their data. And finally, the access control complexity. In many humanitarian international NGOs, managing access control for data is difficult due to diverse roles and permissions. The employee may need access to specific data sets for their job function, but not others. Organization needs to strike a balance between providing users with the access they need and preventing unauthorized access to sensitive information. Let me touch upon some of the basic practical best practices that we can implement. And this is not an exhaustive list. So prioritizing the data visibility and classification through data mapping. As I've said, conducting a comprehensive data mapping exercise to identify all the data points from your organization, what is collected, where it is stored and transmitted. Understanding your data landscape is a first step for effective protection. And then classifying the data based on the sensitivity. This helps prioritize security measures. High-risk data like financial or the individual's client information requires strict controls compared to publicly available marketing or advocacy IC materials. Implementing robust security measures. Access control. Enforces strong access control measures, mechanisms like multi-factor authentication, like most common, everyone knows about the Google two-steps control, access control. So similarly, we can have role-based access control to restrict the access to data based on the user's role and needs. The data encryption at rest and in transit to ensure the confidentiality even if it is intercepted by unauthorized parties. Data loss prevention. Now, the organization in general, most of the organizations have a backup plans to implement the solutions to prevent accidental or intentional data leaks or deletes. And that could be through emails or USB or any other channels. Fostering a culture of data security awareness. Certainly, both the organizations, IOM and Volatus, have mentioned in the principles. They have the culture of training the employees and staff regularly on the data protection best practices, including identifying the punitive attempts, password hygiene, and avoiding unauthorized data sharing. And of course, incident response plan. Develop a clear incident response plan that outlines how to identify, contain, and remediate data breach in a timely and effective manner. Managing the third-party sharing. Vendor risk management. Thoroughly assess the data security practices of the third vendor before sharing your data. Include data protection clause in the contract to ensure the vendor complies with the regulatory authorities. Data sharing agreement. Establish clear data sharing agreements with the third-party vendors that specify what data is shared, the purpose for sharing, and the security measures they must implement in. Navigate the regulatory landscape, compliance. So develop a comprehensive compliance strategy to ensure adherence to the relevant data privacy regulations and stay informed, updated with all the data privacy regulations and adapt your policies accordingly. And finally, leveraging the technological advances, the data security solutions, explore advanced data security solutions, including AIs, like data masking, tokenization to further protect the sensitive information, and cloud security tools to leverage the cloud. If you are leveraging the cloud's storage, utilize their cloud security tools offered to enhance your data protection and promote transparency and user control. Privacy policies, maintaining a clear and concise privacy policies that outlines how your data is collected, used, and disclosed your user data. And finally, the user data request. If you're putting it on your websites, establish a clear procedures for the users to access, rectify, or in case erase their personal data upon request as mandated by regulations. I guess that's it. Thank you.
Thank you, Dr. Rajrathan, and thank you to all the resource persons as well. I know we have overshot time, but we have time for a couple of questions. I see Alok and also Debadrita answering some of the questions on the chat box. Still, if we have any participants who would like to share or comment on any of the sharing so far, you can please unmute yourself. I see a question from Ravi Ranganathan that hasn't been answered yet. Ravi, if you would like to mute yourself and share. Oh, sorry, unmute yourself and share. So Ravi's question is mostly pertaining to how different NGOs collect various forms of personal data from through direct and indirect beneficiaries, and when this data is requested by other organizations or stakeholders, it's shared for monitoring and evaluation purposes, and how this is perceived in the context of Indian law. If Saurav can give an answer to this, if possible, or any other panelists.
Yes, I think, could you repeat the second part, Michelle? Because I think that is where I can give some response to, because the first part is about what different NGOs do as part of their practice. If we could just answer that. I mean, just give me the question once.
Sure. So his question is? So the collection of various personal data of direct and indirect beneficiaries, including children's data, and most of the back donors are requesting the data of individual beneficiaries, and it is shared for M&E purposes. So how is this practice perceived in terms of law in the Indian context?
So at this moment, the way the law treats this is that, once the consent has been taken from the data principal regarding what's usage going to be. So even if, like, in a context like this, what the person who's asked this question has mentioned, that it's going to be forwarded to some donor or for someone else to take some other necessary steps. The first thing that the law suggests is that while taking the consent, that needs to be, the data principal needs to be aware of it. That's the first thing that is there. If the data principal is aware of it and is giving the consent, then it is fine, for the data to be further shared. for these different purposes. Number one. Number two, if in the sense that the consent has not been taken in the way that the consent is supposed to be collected. Over here, currently the issue that we are still trying to figure out, because the rules and notifications are still pending, that how will the data principal first get to know that there has been an unlawful usage of that data principal's data, that it has been shared with someone else? Because how do I need to, if it is just for the purpose of services, for example, I have shared my data with e-commerce firm and then they sell it to someone else from whom I'm getting offers for, let's say, loans or something like that. That may still be a bit easier for me to trace or understand. But in this context, it might be very difficult for us to trace and understand that. So one thing is putting this ball on the court of the data principal as to how they can first figure out whether their data has been shared or not to someone else without consent is something that's difficult. So, but we do not have any answer at this moment as to how the notification is going to take care of that. I mean, that's what I know of. If there are others from the who are in the practice of this, they might be having a better answer.
Thanks, Saurav. So we are close to the end of this webinar. So right before we close, I would like to thank all the panelists and participants for staying with us so long and for actively engaging with the session also. And if all of you, those who can, if you can put on your video, it would be good for us to take a screenshot and share it with all the stakeholders. Take a screenshot now. 3, 2, 1. Thanks a lot, everyone. And once again, thank you to all the participants and all the resource persons for this very insightful session that we had, where we went from the overview of the DPDP Act that is to be implemented and to specific organizational policies and best practices on data management and protection. This has been very insightful, and we'll share all the resources used by our resource persons through email. So please watch out our space for more such sessions. Thank you so much, everyone.
Thank you, Michelle.
Thanks, everyone.
Thank you. Bye.
Bye.
Thank you all. Thank you. Thank you, IM. Thank you, resource person G. Thank you.